Blog Talk Radio.
Good evening, good morning, good afternoon from wherever in the world you may be. This is Nature of Reality Radio. It is February 12th, 2014. I'm your host, Andrew Fisher, broadcasting every Wednesday from 6 to 8 p.m. Eastern from the suburbs of Philadelphia, Pennsylvania. Now, let me just start off by making a little disclaimer here. I got kicked off Blog Talk Radio 2 minutes ago, unexpectedly, lost connection somehow. And I've had sound issues the past 2 weeks. So if I get disconnected or if there's any sound issues, just bear with us, folks. We'll be lasting till 8 o'clock no matter what, even if I have to log in every 5 minutes because I somehow get disconnected. Last 2 weeks had a problem where only everybody else except me, I was the only person who couldn't hear what my guests or callers were saying. Wonder if the NSA is screwing with my computer. I say that all the time. But hopefully that won't be an issue. I heard the woman with the British accent read relatively clearly, so the fact that her voice isn't choppy, hopefully that will mean that my guest, Randy Kelton, who will be my guest tonight, he's an expert on due process and the foreclosure issue. He's a co-host of Eddie Craig and also Deborah Stevens, too, on the Rule of Law radio show on the Logos Radio Network, where Eddie Craig's show airs Monday nights from 9 to 11 p.m. Eastern, and Randy Kelton's show Thursdays from 9 to 11 p.m. Eastern, and there's a 4-hour marathon show on Fridays. I believe that show that Randy and Steve Skidmore are the hosts of on Fridays goes from 8 to 11 p.m. Eastern. We'll be discussing the due process through the courtroom procedure today, how to deal with public officials and whatnot, and also the foreclosure issue. And I would have loved to have Randy's co-host Deborah Stevens on as well to try to kill two birds with one stone. But he said that would be a bad idea because if I did that, Randy would probably be the bird that gets stoned. Yeah, that Deborah Stevens does have an attitude. I love listening to her. She's got some spunk. But anyway, Randy's the host today. Anyway, we'll get him on in about 8 minutes. First, as always, let's start with the news, courtesy of Infowars.com. FEMA to spend millions on large homes that can, quote, become permanent housing. Permanent housing for who? Are they going to be used similarly to FEMA camps? Building FEMA camps all across the country. Folks, if you haven't seen the Conspiracy Theory with Jesse Ventura episode on the police state, you definitely want to make sure you check that one out because that one only aired once on True TV, exposed the fact that FEMA, the Department of Homeland Security, are building camps all across the country, like concentration camps from Nazi Germany to imprison people that don't go along with the system. And they might release a virus to make that happen, and people got threatened. People at Infowars and True TV got threatened because of that episode, and that's why it only aired once, but it's still on YouTube. Watch it while it's still there. The state is a parasite on society is the next headline. The state is a parasite on society. Okay, that pretty much states the obvious. I don't really think I need to state the obvious by talking about how the state is a parasite on society. Our government is not doing the one and only thing which is supposed to do, which is to exert by collective force necessary to protect the rights and property of every single person under the auspices of that government. They're being a parasite. They're far exceeding that authority. Alex Jones turned 40 years old yesterday. Oh, did you have to make that a headline on Infowars? It's kind of out of place, even though it's great that he reached the magic 40 age. His birthday was actually yesterday. Let's see. J.P. Morgan executive becomes fifth banker to die in last 2 weeks. Did he commit suicide or was he murdered because he wanted to blow the whistle on J.P. Morgan Chase corruption? J.P. Morgan Chase is probably the most powerful bank of the banks that control a lot of the things in the world, even more powerful than Goldman Sachs. J.P. Morgan has issued the most debt, and it's interesting if we can find out why this banker died. Naked Ambition, TSA wants new generation of body scanners. Machines will be able to see through more layers of clothing. What, are they going to be able to x-ray your body to see your muscles and your bones? How much more is it going to fry in radiation? Because body scanners are part of a plot of eugenics to depopulate the world and poison us, just like Fukushima is designed to poison us through radiation. Folks, always take the pat down instead of the body scanners. Always. It may be uncomfortable to get felt like that, but the radiation risk from the body scanners, it's not worth it. Always take the pat down. I'm telling you. And what's really disgusting about the TSA, I talked about this last week when I covered the news. I may even talk about it with Randy today, that the TSA, probably the most disgusting thing about them is they relegated you to cargo by labeling you on your tickets as passengers. And passenger is legally defined as a commercial term. So by calling you passengers, they have put you in commerce. And since government has authority to regulate commerce to the point where they can force you to take away your rights if you were to willfully engage in commerce, this means that it's perfectly legal for them to search you the way they do. So arguing the Fourth Amendment or arguing your unalienable right to not be searched without a warrant is pointless because they relegated you to cargo and you're not supposed to know this. Deborah Stevens talked about this, and she said if we change the ticket to traveler instead of passenger, change the word passenger over traveler, we can then sue the TSA for violating our rights because traveler is not a commercial term. Next headline, only 2 House members vote against meddling in Ukraine's internal affairs. The United States is not designed to be the Roman Empire of the modern era, but it is the Roman Empire of the modern era, and many Americans don't realize that because they think they're living in the land of the free. Founding fathers had no clue that they're Illuminati masters. And I'm not trying to demonize the Founding Fathers, folks. They were ignorant of the fact that the Illuminati forces who they work for, the Freemason Founding Fathers anyway, they didn't know what was going on. There's so much compartmentalization in the New World Order Illuminati system that even Freemasons think they're doing good for humanity, and the Founding Fathers took taking good to humanity to an extreme. Now it's everything they stood for is being taken away, and they would not want us to meddle in Ukraine's affairs. And it's good to see that only 2 House members, I didn't read that right. It says only 2 House members vote against meddling in Ukraine's internal affairs. So that's not good. We want more people to be voting against meddling in Ukraine's affairs. Global warming. Lake Superior will freeze over this winter is the next headline. There is no global warming. It's all a scam, and the winter we're having is all the more confirmation of that. I'm prepared for a big storm in this area tomorrow. Good thing I'm able to get this show in, because if I was doing the show in the weather we're supposed to have tomorrow, there may have been no show because I'm sure a lot of people are going to lose power. It was nice to see the Whole Foods store near my house giving food to people who lost power. But here, one more headline before I get Randy on. Second possible terror attack on U.S. power plant uncovered. Gunmen used boats to access Tennessee nuclear facility. Oh boy, a terror attack on a power plant. Now that would be bad. Well, it already is bad. Alfred Weber, who was on my show several weeks ago, talked about how some sort of government weather modification technology, it wasn't HARP, it was some other one, caused the earthquake in Japan in March 2011 that caused the tidal wave that destroyed Fukushima. And David Icke talked about how the Fukushima blasts were set off to maximum capacity. That can only happen if it was set up, and the cameras that were put in the Fukushima shortly before the disaster looked exactly like bombs that caused that kind of explosion that we saw. And there's the evidence it was staged. And even though Earth's axis, and this is according to George Kavassilis, Earth's axis may have shifted a little bit shortly before the earthquake, that does not necessarily mean that the earthquake alone the Earth's axis shifting caused that earthquake. Alfred Weber did say we identified the weather modification technology base that was used to cause the earthquake. So at the very least, even if that earthquake was caused by Mother Earth, it was still exacerbated, made worse by that weather modification technology. So that's the deal with Fukushima. We don't need any more power plant attacks, because unless there's some sort of higher dimensional entity intervention, as Alfred Weber said, we'd be totally screwed and fried in radiation. And, there is evidence that higher dimensional entities are watching over us to protect us and keeping Fukushima radiation in check. But that falls out of the scope of this interview anyway. So without further ado, I am going to let Randy Kelton on, and boy, I sure hope I'll be able to hear him clearly. I hope there'll be no choppiness here. Randy, you are on the air. Can you hear me?
Yes, I can hear you, and I understand what your problem is in Philadelphia. I was doing a show with Pastor Massett last night, and I figured it out. It is so cold up there, your signal keeps sliding off frequency. You should be in Texas, where it never gets cold. Can you hear me? I think perhaps I have slid off the track. Let's try this. Hello, Mr. Fisher. Can you hear me?
Yeah, well, you know what? You just started breaking up as soon as you started talking about why you're going to break up, so I think the only way we're going to be able to do this show, because this is probably going to keep happening, I'll make sure I listen to this again so I hear what you said and this whole show again, but if it's really the weather, this means it's going to happen. And the only way I think we're going to be able to do this show is if I'm going to have to pose a question for you, and you're going to have to keep just answering it, and as soon as I hear you stop talking, and for like 2 to 3 seconds, I'll move on to the next question. There's really no way we can engage in conversation if your voice is going to break up like it did the last 2 shows, so it's just going to have to be me answer the question, you answer the question, and then after 2 seconds or 3 seconds of no sound on my end, I'll move on to the next question. So, that okay with you?
That's okay. Ask.
All right. You are breaking up. Okay, it is the weather. Thank you for clarifying that. I'll find out everything. But I suppose we might as well start by having the audience know you. Who are you? What are you an expert in the world of law in regards to due process and the foreclosure issue specifically, but maybe some other things. And then after you give a little life story on yourself and the important things that in life that led you to do what you do, we'll move on to questioning.
Okay, I am not a lawyer. I am an engineer. In 1981, I spent the night in jail for driving with a headlight out. That did not seem right, so when I got out of jail, I got out the Texas Penal Code and Code of Criminal Procedure, and I read them. And then I looked at the practice of law and compared it to what I read in the codes, and I thought I must have stepped through the looking glass. I could not understand how the practice was so different than the code. And being an engineer, this became an engineering problem. I spent 15 years trying to figure out what it was I had missed. And after some 15 years of research, it was clear I hadn't missed anything. Our public officials simply were not following our law. Another 15 years of research told me how to fix it. It actually told me what the real problem was. At first, I thought it was the police who were acting outside the rules we laid down for them. And then I blamed the prosecutors for not prosecuting these errant public officials. And then I blamed the judges, and it finally reached a point where there was no one else to blame but myself. We in this country have forgotten who we are, and I'm not talking about the sovereigns. There are some sovereigns, those whose ancestors fought in the revolution. The rest of us are not necessarily sovereigns. We are the masters. When we deal with our public officials, they are the servants, we are the masters. And we have allowed the servants to take control of the masters. And most everything I do on my shows and seminars is about bringing us back to the position of master. Does that pretty well handle it?
Okay, Randy. Didn't hear a damn thing you said there because of the breaking up, but I'm assuming you're done because I heard silence for 2 ends. So I guess we'll start with the questioning about the law. And I think the thing that really intrigues me with that you've talked about on your show is dealing with public officials, because it's become clear that simply citing what you think the law should be, like saying government was only created for this reason, I cause no harm, therefore there's no crime, I can't be charged with a crime. Well, that doesn't necessarily work. And another example you've talked about is electronic filing. It can be proven that they broke the law by filing court records electronically. So ever since 2001, I'm guessing this was as a result of September 11th or something, they filed it electronically, and that's illegal. So all those cases should be were due process violations, but arguing that in court is not going to get your case dropped. So could you elaborate on that? And then after you elaborate on that subject of court records filed electronically of being illegal, elaborate on how to deal with public officials. Take all you want. You got the floor. Take as long as you need.
Primarily, the point of electronic filing is a very focused point, and that's only focused on the electronic filing of records that are filed with the county registrar's office concerning real property. Otherwise, electronic filing is legal under law, and it's not necessarily a problem. Electronic filing, I just used it in that instance to annoy the courts. The issues of public officials. I've tried to structure a way of thinking about public officials that would make sense to the ordinary individual. And it boils down to this. If we are to take back our system, you and I, if we're to do it and not wait for someone else to come along and be our savior, if we're to take back the system, we must follow a few rules. And the first one is never ask a public official to do anything that you actually want that official to do. Now, I know that sounds counterintuitive, but the reason you never ask a public official to do anything you actually want him to do is that you never ask a public official to do anything that the law does not specifically require him to do. Public officials, for the most part, do not have discretion as to whether or not to perform their duties. Neither do they have discretion to perform acts they are not authorized to perform. So if you ask a public official to do something that the public official is not specifically required or authorized to do, the public official has no power to do that. And they're not going to tell you, they're just not going to do it. And then we get all excited, jump up and down, wave our arms in righteous indignation, file accusations and claims, and the claims go nowhere. The claims go nowhere because there's nowhere for them to go. Never ask a public official to do anything that the public official is not specifically required to do. Now, that takes a discipline. That takes research. That takes time and effort on our parts. But if you and I are to bequeath to our children a more effective system than we received from our parents, we will have to exercise a certain mental discipline. But there is a benefit to that. It certainly has an upside. When you go into a court or a public office and you ask a public official to do something the public official is required to do, you're not really asking. You are commanding because you are the master. And when the public official doesn't do what the law requires him to do, you get to land on him like a ton of bricks. And we probably don't have enough time in this show to go through all of the things that we can do. On our regular Thursday and Friday night shows, we talk about running the routine on the system. And in running the routine on the system, it's about asking a public official to do something he's required to do, and when he doesn't, we go to the official who is in a position to take action against other officials who don't perform their duty. Every state has a statute that reflects the Ku Klux Klan Act of 1871. The Ku Klux Klan Act of 1871 has been codified into law as 42 U.S. Code 1983. Now, that's something a lot of people are familiar with. It authorizes a citizen to sue a public official when the public official fails to perform a duty they're required to perform or exerts or purports to exert an authority they do not expressly have, and in the process denies the citizen in the full and free access to or enjoyment of rights. That's the second half of the Ku Klux Klan Act. The first half was codified into law as 18 U.S. Code 242. And that is a criminal statute, and it states that if a public official fails to perform a duty he's required to perform, or exerts, or purports to exert an authority he does not expressly have, and in the process denies a citizen in the full and free access to or enjoyment of a right, that is a criminal act. And it's a crime in every state. In Texas, the statute that reflects that prohibition is Texas Penal Code 39.03, and it's worded almost exactly like the federal statute. And most of the statutes around the country are also worded almost exactly the same. That is a catch-all. Any time a public official fails to perform his duty or acts under color of law, color meaning pretense, and exerts or purports to exert an authority he does not have, he commits a criminal act. And as a citizen and as the master, it is your duty to report crime when you have knowledge of it. And the police have a vested interest in cooperation with the public. The police really suck at catching criminals, so they need the citizens to help them do it because they're too lazy to do it themselves for the most part. So they make sure to protect those who report crime. And that's a good idea. If I report a crime against you and you do anything to me, the police will come and just thump all over you for that. Their problem, when you report crime to them against one of them, now they get really excited and they really don't know how to handle that. This generates a specific phenomenon we tend to call a chicken dance. If you want to see a public official do a little chicken dance, just call the police on the police. And when the policeman you call responds to your 911 call, and you ask him to arrest a public official who's a friend of his, he finds himself in a quandary. You are a protected class. You are the victim. You are performing your duty, reporting crime, but he really doesn't like the crime that you're reporting. When I call a policeman to arrest another policeman, they have to be very, very careful because the policeman I call is wearing a loaded pistol. Now, we see that all the time. We get sort of accustomed to it, but, well, you may get accustomed to it. I'm a combat veteran. I never get accustomed to it. I was a weapons specialist in the military, and I want everybody to have guns, but I don't have one. I don't want one around me because I've spent too much time on the sharp end, and I've saw what horrible things they do to human beings. So I don't want one. And when a police officer puts one on, he puts on a terrible responsibility. And he better be very, very careful. A misstep while you're wearing a loaded pistol under law becomes a very big deal very fast. For instance, in Texas, 22.04B2A Texas Penal Code. 2204 is the aggravated assault statute. If a person commits simple assault as defined by 2202, while prominently displaying a deadly weapon, that is aggravated assault. If the person does so while acting under the color of or pretense of an official authority, that's a first-degree felony, 20 to life. So when I call that police officer out there and ask him to arrest his buddy, and he tells me how much trouble I can get into, then if I'm not careful, bad things can happen to me, that gets another 911 call. Charge the officer with shielding from prosecution in violation of 38.05 Penal Code, and first-degree felony aggravated assault. If you're in a public building and you call the police on the police and they come and order you to leave the building or be arrested, under the Texas code, if someone threatens you for the purpose of denying you access to a public building or for the purpose of restricting your access to a public building, that is a terroristic threat. And I filed that against my district judge with the Attorney General of the state of Texas, and that was such a hoot. And this is the backside of doing this, the thing you have to really be careful about. It's not them retaliating against you. That's not going to happen. They'll become afraid of you. They won't want to see you. They won't want to talk to you. They won't want anything to do with you. The problem you'll have is you will find that this is way too much fun. When you start taking their law back to them, they get real excited real fast because now they're in a catch-22. They're caught inside a paradox, and they can't find a way out of the dilemma you put them in. It is never my intention to get a public official indicted. I file against them all the time with the grand jury, but I never want one indicted. I want my public officials to abide by and enforce my law. Not your law, my law. You're in Philadelphia, so I'm sure you're aware of what Benjamin Franklin told a woman who asked him when he came out of the Continental Congress, "Mr. Franklin, what have you given us?" He did not say, "I have given you a monarchy." He did not say, "I've given you an oligarchy." And he did not say, "I have given you a democracy." He said, we have given you a republic if you can keep it. By that he meant he did not give the law to the will of the people. He gave the law to the individual, and it was the right and the duty of the individual to keep it, not to wait for somebody else to do it for him. This is basically what we do. We show people how to be the monitor of our police, how to be the master. The most fun I've had is telling a little sawed-off, smart-mouth prosecutor that seems to have forgotten that he was a public official. And he said, "Yes, Mr. Kelton, I'm a public official." You're public servant. He said, "Yes, Mr. Kelton, I'm a public servant." "Yes, you're the servant." And I tapped my chest. "Me, I am the master, and you are not to forget it." He forgot it. 2 weeks later, he was working for an oil company. When you walk into a courthouse, you are the baddest motor scooter in the building. And the only reason you're the baddest motor scooter in the building is that you're nobody. You're not a bailiff, constable, police officer, court clerk, lawyer, prosecutor, judge. You are their masters. You are the master of all of them. And everything we do on our show is about demonstrating that we are the masters and demonstrating how to act like the masters. Andrew, you still there?
Okay, Randy, I'm sure you're done talking there because I heard 3 seconds of silence. Definitely going to have to listen to this all again. I can only hear about 65% of what you said, and I actually did get disconnected. Want to let you know that. So there may be a couple times throughout this show where the cold weather will cause me to get disconnected. If that's the case, just bear with me. I promise you I'll get back online. So thank you for covering that. I hope people will pay very close attention to that if you can entrap, so to speak, public officials, then it can work out in your favor. So next thing I want to talk about is when can a crime be a felony? Because many laws that say you'll be charged with a crime are not legal for the simple fact that you didn't cause any harm. There is no corpus delicti, therefore there can be no crime, like simple possession of drugs. And yet they will charge you with a felony if it's a drug like cocaine, even though you cause no harm. Now, this is a case where a felony not only shouldn't be a felony, it shouldn't even be a misdemeanor or a summary offense because it's a crime the government never had authority to pass in the first place. So when does it become legal to make a crime that causes harm a misdemeanor, a summary offense, and a felony? When can the government do each one?
We have granted our legislature the power to make law. And that power was only restricted by those prohibitions in the Constitution. They have the power to make these laws and bind them to us by virtue of the contract we entered into with our public officials when we enacted our Constitution. This is a contract, and we're bound to the contract. The notion that there can be no prohibition if there is no injured party is simply not true. What the states claim, and what is specific in Texas law at least, is that when a penal statute is violated, the state is necessarily an injured party by the violation. So they get around this claim that there is no injured party. That is not an issue I've ever taken up. There are a lot of arguments that go to legal theory, and that one does. I don't go to legal theory. I go to what the law says. I don't need to negate the penal code. I need to use it. I have a federal judge here in Fort Worth who regularly dismisses my cases with prejudice. Well, I've set up a number of cases, filed them in the state court, knowing that the lawyers on the other side will always remove them to the federal court. And these cases were very carefully crafted so as to have no federal claims. And under a relatively new statute, the Federal Court Venue and Removal Clarification Act of 2011, a federal judge in a case where a matter has been removed from the state to the Fed may hear the case, though that portion of the case that concerns federal issues, but must sever the state issues and remand them back to the state. So it's been a common practice for this judge. Whenever a pro se litigant files a case and the lawyers remove it to the state, the federal judge dismisses with prejudice out of hand. So I'm going to maintain that the federal judge acted without subject matter jurisdiction because he is specifically forbidden from ruling on the state issues, and that the judge failed to perform a duty he was required to do by statutes, i.e., sever the state claims, remand them to the state. And all of the claims were state claims. And then he exerted or purported to exert an authority he did not expressly have. And he did so under the color of his authority as a federal judge, and in the process denied me in my right to petition the court for redress of grievance, which in the federal Constitution is called outlawry, and it is specifically forbidden. Now, the problem the judge has is he's in a federal courthouse in Fort Worth, Texas. That federal courthouse is not a federal enclave. That is a building that belongs to the state of Texas. It has never been ceded to the federal government. The only property in Texas that has been ceded to the federal government are a couple of federal prisons. And that's so that the feds can use their own police in those prisons. Everywhere else belongs to the state. That federal courthouse is in the state, and that judge is subject to the state law. So I will be taking him to a local grand jury and see what they think of his shenanigans. We have all of the tools we need written into the code. We don't have to get around the code. We don't have to try to get to the maritime when the maritime doesn't apply. We can take the very code they pretend to use and cram it right down their throats. This has been very effective. We're gaining more and more converts, more people who come to realize that the one thing the courts fear more than anything else is the pro se litigant. They don't fear and hate pro se litigants because pro se litigants write stupid pleadings. They like that part. Makes it easy to screw them. They hate pro se litigants because every once in a while they come across the pro se from hell. The pro se who knows and understands their weaknesses, who is familiar with the law that governs them and knows how to take that law back to them, take them to task for that law. That's what we teach, that's what we do, and we found it very effective.
Okay, Randy, I take it you're done, so let's move on to the next subject involving law. One thing I'm interested in talking about is the subject of police lying, because a couple of things to elaborate on here. First of all, it's been ruled by the Supreme Court that police have the right to lie to get a confession. They can't lie under oath, and they cannot lie to you about your rights. That would be illegal, but any sort of general lying to get a confession has been ruled by the courts to be legal. However, a couple of issues with this. First of all, Eddie Craig, your Rule of Law radio show co-host, on his script, he has, at the end of his script, when the cops pull you over for a traffic stop and they say, "Sir, I smell marijuana and alcohol in the vehicle. I'm going to have to ask you to step out of the vehicle." That's when you say, "Officer, your statement is patently false and an outright lie. Are you now trying to fabricate probable cause by making false statements into the record and false allegations against me?" Now, that statement, if someone reads that, that would lead them to think, oh, well, it's illegal for the cops to make false statements and lie to fake probable cause. And the second thing that kind of violates the legality of police being able to lie is they're your servant. If it's illegal for you to lie to the police, which the courts say it is, and you can get into legal trouble for that, then how could it be legal for your servants, the police, to lie to you? I mean, common sense would say in that case, if it's illegal for them to lie, it must be illegal for you to lie and vice versa. Or if it's okay for them to lie, then it has to be legal for you to lie to the police. So is it really legal for the courts to rule that police can lie to get a confession like that? And if so, what makes it legal?
Well, actually, statute makes it legal. And when we complain about these issues, especially this issue this way, we have to be careful what we ask for. We put our police on the street for the purpose of enforcing law and reducing crime. And because we have a few policemen who abuse their authority, we would completely bind the hands of all of the good policemen out there. I know a number of police officers. I do not know a single police officer who decided to get into law enforcement so that he could be a jackbooted thug. Most police officers got into this business so that they could be the good guys, so they could help people. They got into a system they did not create. And most of the policemen I know hate the system that they're in. They know it is horribly corrupt and wish it was different, but they can't change it. There's only, I used to say there's only 2 really corrupt police officers in Texas. The problem is they get around a lot. And the problem the police have is nobody comes in here saying, what a great job this policeman did. This policeman did his job. I do this on a regular basis. I had a police officer on I-35 pulled over a truck and came around the truck and cut right out in front of me. I had to drop 2 lanes over to dodge him, and it was incredibly heavy traffic. Unfortunately, every driver had his foot on the brakes, or there'd have been a major pileup out there. I pulled over behind this officer, got out of my car, and crawled right down his throat. Just really gave him a reaming. And he stood there and listened to me, was polite to me, apologized to me, agreed with me that he had been careless, that this was his fault. And I made him give me his card, and I ripped it out of his hand, and I told him, you'll be hearing from the director over this, because I dropped a few names that I knew who they were, and I stomped back to my car, got in the car, and slammed the door and drove off, thinking that was a good police officer. And I called his sergeant and told him what happened and explained to him how much I appreciated the fact that no matter how obnoxious I got with this police officer, no matter how aggressive I got with him, he never lost his professional decorum. And I told the sergeant, if I need a police officer with a pistol, send him. He's not going to lose his perspective because somebody doesn't do something he likes. He's not going to act stupid because somebody defies them. That's what I want from a police officer. We need to give our police officers room to do their jobs and only go after the ones that don't do their jobs. It's inappropriate for us to generalize from a single incident to the entire department. How many times have you called a police officer's superiors and told them what a good job you thought the officer did? If we're going to go in complaining about the bad officers, we need to be just as quick to compliment the good officers. We have a police department out of hand not because of the police department. We have one out of hand because of ourselves. We created this mess. So I'm not going to advocate tying the officer's hand more than it needs to be. Yes, the officer can lie to you, deal with it. If an officer speaks to me, I assume he's lying. And I'll tell him very quickly, I don't believe a word you're saying. Don't tell me anything, show it to me. If you're saying that I have to do a certain thing, tell me what law it is. This goes to one of my rules. Never make a proactive statement of law out of your own mouth. Always make proactive statements of law out of the mouth of the courts or the statute. So, if you say you have a right to do certain thing, no, you don't. Prove it. And if you attempt to do it, I'll take out my cell phone, dial 911, and ask an officer to come down here and arrest you for it, and you can explain it to them. This is our job. This is how we fix it. I'm just concerned that a lot of the things we're asking for are based on false premise, based on the premise that because a police officer can lie in one circumstance, that he will lie in all circumstance. That a police officer that because we fear they will lie, we should force them to tell the absolute truth all of the time. We're going to leave a lot of criminals on the street. The laws that authorize the policemen to lie were primarily authorized for use in sting-type situations, where they're giving up people who are intent on committing crime opportunity to commit that crime so that they can enforce the law and give them reason not to do that in the future. That's not an unreasonable policing power. The fact that the police abuse the powers we give them, that's our responsibility. You can't blame that on the police. You have to blame that on yourself. If you have been abused by a policeman and you didn't do your job as the master and get that policeman straightened out, we deserve what we get. We create this, and this will never, ever go away so long as we ask somebody else to do it for us. I am especially concerned with the passage of new law. I've done seminars all over the country, and every state I've been into had an extremely well-crafted corpus juris, body of law. We have all the laws we need to cover most every situation that comes about. We don't need a new law passed for everything that annoys us. We'll wind up like Australia. Our penal code is about 100 pages. The Australian Penal Code is 500 pages. Nobody can read all that and understand it. They have so many laws, they've been passing laws for so long that you can't breathe twice without breaking one of those laws. So I'm reluctant to go into these issues this way under the premise of either adding more restrictions or changing the law in any way. The law is great like it is. Just use it. If a public official lies to me in a way that would have the effect of denying me in a right, if he lies for the purpose of searching my vehicle, that's a crime. The lying's not a crime. The denial of my right, that's the crime. A breach of due process, that's a crime, and it's also harm per se. You don't have to claim that you were harmed by the officer illegally searching your car. That is harm per se, on its face. So we have the remedies that we need. If a police officer denies you in one of your rights, make up a tort letter and send it to the county commissioner's court if he's a county officer. If he's a municipal officer, make up a tort letter and send it to the mayor. And tell the mayor, I was harmed. I was denied due process. That's harm per se. And I take my rights very seriously. I consider my rights very valuable. Pay me $200,000 to make me whole or be sued. I guarantee you the mayor or the commissioner's court judge is going to get real excited about that, and he is going to have some questions for the head of the policing agency. And the head of the agency is going to have some real questions for the guy below him and the guy below him, and when it gets down to this officer, they're not going to care what he did. Just that everybody's getting in trouble because of you. Anyone here who's ever been in the military will understand how this works. It all rolls downhill, which goes to the premise that everything is political. A lot of people, especially in the legal reform community, have some idea that if you find the right law You find exactly the right statute, and you apply it in just exactly the right way, well, magic things will happen. Well, I got bad news for you. You will never win your case simply because you have the law and the facts on your side. To think so is naive. It is not that way now. It never has been that way. I once read an interpretation of a plaque commissioned by a king in 3500 BC. It was Sumerian. And in that plaque, he proclaimed that he was reasserting the old law because those in positions of power and influence had so perverted the laws that the citizen could no longer achieve justice. If this has been going on for 5,500 years that we know of, don't expect it to change tomorrow. Everything is political, and all politics is local. You will win your case if you create some local politics, and of all the people in the courthouse, the one person who can create the most political turmoil is the master. It's you. These public officials are not going to be afraid of you. What they're going to be afraid of is the political cannon fodder you're going to give to their political opponents, to their next opponent they're running against, or the political pressure you can put on their boss's boss's boss. Because you are the master, you go right to the top. I have filed a great number of criminal complaints with the Chief Justice of the Supreme Court of Texas. And when he refuses to act on it, I run right down to the district attorney and demand that he arrest that scoundrel. And the district attorney refuses. So I run to the attorney general and demand that he arrest the district attorney for not arresting the attorney general. And when the attorney general refuses to act, I run back to the chief justice and ask the chief justice to arrest the attorney general because he wouldn't arrest the district attorney because the district attorney wouldn't have him arrested. Now, this gets everybody really excited because the Chief Justice of the Supreme knows the next time he runs for office, I'm going to be waving these criminal accusations in front of his opponent. Now he's going to have to explain these. And he's going to say, oh, all of those complaints were frivolous. Well, maybe. But the other rule is perception is everything. Here we have the Chief Justice of the Supreme Court of the state of Texas that doesn't even know that he's a magistrate when 2.09 Code of Criminal Procedure says, who are magistrates? First one, justices of the Supreme Court. What part of that is hard for you to understand? 2.10 makes it the duty of every magistrate to enforce the law in the state. 2.11 states that when a magistrate sits for the purpose of examining into a criminal accusation, that's an examining trial. The judge did not hold one, failed to perform a duty he was required to perform, and in the process denied me the full and free access to or enjoyment of right, I want him arrested. I'm the master. I can do that. If we're going to fix the system, this is how we're going to do it. Before we start looking to change the laws that have been carefully crafted for the last 200 years, they've been crafted by no good, rotten scoundrels. And that's a good thing. The checks and balances written in the law were not written in there to protect you from them. Scoundrels wrote them in there to protect themselves from each other. And we get to use them against the scoundrels. That's my story, and I'm sticking to it.
Okay, Randy, thanks. Heard you finish there. Didn't have to worry about the breaking up factor to hear you finish there, but I did lose connection twice. I have a feeling this might get worse as the night goes on, and I hope I'm wrong. But thank you for covering that. I look forward to listening to everything. I have no choice but to listen to this again. But next subject I want to talk about is the ability to use disabilities, mental disabilities in particular, as defenses. Because I once called into Eddie Craig's radio show and asked him about this. And I asked him when, if you have some sort of that you've been diagnosed with some sort of a mental disability, like maybe an autistic spectrum disorder or something, and you commit a crime, and you try to use the defense in court that your disability played a role in you causing the crime, therefore you should have the charges dropped, or at the very least you should have the sentence lowered because your disability made you commit the crime. And I asked Eddie, when is it legal to use, not legal, but when are you capable of getting out of a crime or getting your sentence lowered using this defense? And Eddie's answer was, really that simple. And he said, yeah, there isn't any sort of a defense for disability set in stone in the law unless you use the defense of insanity, which opens up a whole new can of worms. So, the point is, someone who gets off sexual harassment lawsuit because of a disability, well, just because they got off doesn't mean that someone else will be able to get their sexual harassment lawsuit dropped because of a disability. But insanity opens up a whole new can of worms, Eddie said. So, Randy, please elaborate on that. What did Eddie mean when he said insanity opens up a whole new can of worms?
Oh, I absolutely agree with Eddie. Be careful what you ask for. You can use mental disability to negate a primary element of a crime. You hear a lot of people in the legal reform community complain about thought crimes, about how they're passing thought crimes. Well, guys, all crimes are thought crimes. The crime is not what you did. The crime is how you held your mind when you did it. As an illustration, I once punched a woman up beside her head with every intention of knocking her smooth out. So, would that be a crime? I know on the surface it sounds like a crime. It sounds like a crime of assault, if not aggravated assault. However, at the time we were about a quarter mile out in Lake Michigan. We'd been caught in a riptide, and she couldn't swim, and she was drowning. I went out after her and got caught in the tide with her. I got to her, and she latched on to me and nearly drowned us both. I got her loose from me and came back up. She grabbed me again. The third time we went under, when I came up, I whacked her upside the head just as hard as I could with every intention of knocking her cold. Because the only way I was going to get her out of there, I could have swam away from her at any time, but the only way I was going to get her out of there was to get her stopped trying to kill us both. Well, that worked. She quit trying to kill us both, and I got her drug in. And by then, the lifeguards had realized what was going on. They come out and helped me, and they took her from me and took her on in. When I got into shore, a lifeguard walked over to me and said, she has a pretty good shiner. And I asked her, but she doesn't know how she got it. Oh, yeah, I did that. You did that? Yeah. And I tried to knock her out, but I guess I didn't hit her hard enough. He said, no, you probably didn't. You need to do better next time. So, no, that was not a crime. And it had nothing to, it wasn't what I did. It was how I held my mind when I did it. That is the primary element of a criminal act, is intent. And mental infirmity of one type or another can negate that element of the crime. You cannot be convicted if you cannot be shown to have had rational intent. However, if you claim that you had a mental infirmity, then that opens the door for restricting a lot of what would otherwise be your unchallenged right. If you are technically or legally blind, it is reasonable to restrict your right to drive a 3,000-pound piece of iron, or to push or navigate a 3,000-pound piece of iron down a highway at a high velocity without being able to see accurately, because you put all our friends and neighbors and wives and children in unreasonable peril. If you go to the court and say, oh, yes, I raped her, but I couldn't help it because I'm a sex addict. Well, okay, you might be able to claim that defense. But then we won't put you in jail for the rape. We'll put you in a mental institution for the criminally insane. How does that work for you? So, as to the mental infirmity defense, I would suggest that you use that with great care. That's my story.
Okay, Randy, thanks for covering that. One thing I think is very critical to get out here that a lot of people are not quite aware of their power to do this, the subject of jury nullification. Many people do not understand what their rights as a member on a jury are, and I think it's important that we cover this. So to the best of your ability, Randy, please talk about jury nullification and what rights a juror has in regards to due process and courtroom procedure.
Okay, we go back to Thomas Jefferson. He explained very clearly his intent of the purpose of a jury. It was the intent of the crafters of our Constitution that juries have the power to invalidate illegal, improper law. What he said is that the jury is the last bastion to bad law. If the jury refuses to enforce a law, the legislature will have to change it. It's important to understand that principle. When a judge gets up there and says, you determine the facts, I will determine the law. If I'm on a jury, I won't say it to the judge, but I'll be thinking, I will determine the facts, and I will determine whether or not to apply the law you push at me to those facts. I don't care what you say. And as a juror, you have no duty to care what the judge says. It was intended that the lives of our citizens be left in the hands of our citizens. It was actually intended not just that you be judged by a jury of your peers, but by a jury of your neighbors, by people who knew you, were familiar with you. They could best judge your character and the veracity of your testimony and the truthfulness of testimony against you. That's how it was intended. Now, if a juror knows an accused, the lawyers will work real hard to keep that juror off the jury pool, because they don't want the jurors, to assess the testimony based on their perception of the witness. They want them to treat all witnesses as equal, unless, of course, they're police officers or their own witnesses. Then they want them given more credibility than the others. But that is as it should be. The advocates should advocate for their sides. They should try to get the best situation for their sides. Both the prosecution and the defense, or if it's civil, both sides should work to get the best deal for themselves. But the jury must remember, the judge can say anything he wants to. Our founders understood the tendency of judges to take control of the judicial process. And they created a set of procedures that, by their very structure, tended to nullify the effects of judges trying to superimpose law on jurors. I haven't seen as much problem with jurors being affected by the courts as I hear people talking about. The bigger problem is the pool itself. We have to understand that you and I and most everyone listening here, we tend to be those who are what is called awake. But the vast majority of the public is not. If I go to my mother, who's 92, and I tell my mother, you know the law and the legal system that you have trusted all of your life, wow, that's all a bunch of hogwash. You can't trust him. If I tell my mother that the United States has become the worst police state the world has ever seen, what would she have to accept in order to believe what I said? She would have to accept that all of her beliefs, that all of those comforting beliefs that in the cold of night gives her comfort, she would have to accept that that's all wrong, that she has no security, she's not protected anywhere, that at any moment everything can be taken away from her and she can be thrown in jail on the whim of a public official. What is it going to take to get the vast majority of the public to buy that story? The big problem in the jury pool is not nullification of the jury by the judge. The big problem in the jury pool is the inability of the jury itself to hold the system itself up to the same scrutiny that they hold the parties. I could probably spend a long time on this one, but I believe we are, for the most part, going after the wrong issues. First and foremost, we have to reestablish the republic. We've become a democracy. It was never intended that we be a democracy. It was intended that we be a republic of empowered populace, and we are not that. A good portion of the people in the legal reform community, I hear them railing against the wrongs, but I don't see them stepping up and stepping out and taking action to change those wrongs. So many of them are simply waving the wrongs in front of us with the unstated presupposition that somebody ought to do something about that. Well, I think that's a lot of the problem. There is no somebody to do something about that. There's only you and there's only me. And those of us who are awake and understand, it's our job to stand up and do the hard part. I accept that I was given this path in life, that this was my job to do this thing. Other people have different paths. Everybody's not going to go down the same path as I, and it's not necessary. Great change has never occurred because of the will of the masses. Look back in our history. Great change is always accentuated by the charisma, by the force of an individual or a small group of individuals who gave the masses something to rally behind. So I don't have the problem with the jury nullification that most people do. The jury is what it is. It's always been what it is, and I don't see that the courts have had any great effect on the jury. And I don't think they're going to in the future, and I don't see a great need for any change of law. We're going to get that same jury pool. We just need to better pay attention to the pool that we're dealing with. Don't know if you can hear me, Andrew, but that's my story, and I'm sticking to it.
Okay, I heard you finish that one. There was no interference when you said that, so I know you're done. But anyway, thank you for covering that. We might talk about law later on, but I want to get a little bit into the foreclosure issue because, and what exactly foreclosure issue means. I'm assuming it has something to do with the banks foreclosing on your house if you fail to pay your debt back. I mean, we all know our financial system is completely untenable because the banks loan us money that does not exist and charge us interest on the loans, which makes debt and inflation unavoidable. And for every person that can pay his debt, there will always be someone who cannot pay his debt. And when it all comes down to it, it's all the bank's fault because they make money that out of thin air, and it's not backed by jack squat. So the foreclosure issue, what's the big deal with what you know in regards to the foreclosure issue, and then elaborate on what we should know about it.
Okay, I have been working in this area for several years now, and I have come to the conclusion that the banks have been sending us down a bunch of rabbit holes. This notion that there is no money, that's true. In mortgage issues, there really isn't any money. But always when I bring an issue before the court, I assume that when I bring the issue, the judge is going to say, so what? So there's no money, what does that have to do with anything? And the importance of that position is, this is not about money. This is about a contract. When you go to the table, the lender brings a warranty deed to the property. Now, that lender got that warranty deed from the seller. How the lender got the warranty deed from the seller is not your business, unless he stole it. If he got it from the seller in a way such that the seller will not have a claim against the lender for securing the deed, the warranty deed, then it's not your business. The lender trades you a warranty deed to the property in return for a promise to pay him a certain amount of United States dollars over a given period. That's a contract, offering acceptance, something of value changed hands. The warranty deed changed hands. That was something of value. And you returned a promissory note, which was of value. So where the money comes from and why there's this argument that there is no money is that the bank gives the impression, and I'll explain why I say impression in a bit, the impression that since they are a licensed lender and have a fractional reserve account, that they go to the Fed window with your promissory note and say, I have this indenture, and based on this indenture, I want to draw X amount of dollars out of my fractional reserve account. So the Federal Reserve says, okay, and they go over to a ledger and they put a mark on a ledger. And by that mark, they create these funds out of the thin air with the agreement that when the funds are paid back to the bank by the by the borrower, that these funds the Feds created out of the thin air will be put back into that account, be marked off the ledger, and go back to the thin air from which they came. This increases the velocity of money without increasing the volume of money. So the perception is by a lot of the people in the legal reform community that the money is created and it stays in circulation. It does no such thing. Or at least that's the idea. That's not what really happened with Bank of America, Wachovia, Washington Mutual Bank, Wachovia, Deutsche Bank, and now Bank of America, J.P. Morgan Chase are being investigated for this. What Washington Mutual Bank did is they came to the table as the lender, when in fact they were not the lender. They were the pretender lender. They were pretending to source the funds from the Federal Reserve, when in fact They got the funds from a special purpose vehicle, an investment vehicle, put together for the purpose of securing a large pool of residential mortgages they could then aggregate into a pass-through trust. They would file that pass-through trust with the IRS as a real estate mortgage investment conduit and then sell it to investors like your retirement funds. They would sell tranches. You'll hear the term tranches. A tranche in this regard is a slice off that entire fund. You got 10,000 notes here bundled into one investment conduit, and they sell 10%. They take a 10% slice off of it, and they give it to this investment pool. Well, turns out that with Washington Mutual, the special purpose vehicle was the source of the funding. And where the special purpose vehicle got their funds was from the Colombian and Mexican drug cartels. We hear about this foreclosure, this real estate bubble debacle, as being the largest Ponzi scheme in the history of mankind. It was more than that. It was the largest money laundering scheme in the history of mankind. And Washington Mutual's problem was they screwed up and competed with the CIA in their drug operations. So the CIA come in and shut them down. Wachovia, they caught Wachovia red-handed laundering $385 billion. Or billion or million. That they caught them red-handed with. That's what shut down Wachovia. Deutsche Banks in Germany, we couldn't shut them down, but they admitted to it. J.P. Morgan Chase, Bank of America, and Wells Fargo being investigated for that as we speak. So, as far as no money, well, if it worked right, there would have been no money. Money would have came into existence and went right back out of existence, and the velocity of money would have increased, but the volume would not. As it is, the illegal drug money came into the market and stayed. When it was paid back, it became laundered funds, making the drug cartels some of the richest entities on planet Earth. And that should make you comfortable to think that the really, really bad guys, the worst of the worst, are the richest of the rich. Okay, to foreclosure. When a bank exercises a foreclosure, there are two different kinds of foreclosure. We have judicial states and non-judicial states. If you're in a judicial state, when you enter into a mortgage contract, there are three documents: a deed of trust, a warranty deed, a note, and a security instrument. If you're in a judicial state, that security instrument is called a mortgage. But that's just the name of the document. It is actually a security instrument intended to secure the promise in the promissory note. The warranty deed is given to the seller, is given to the buyer, and in return the buyer gives the note and security instrument to the lender. Well, if it's a judicial state, the security instrument contains a privilege granted to the lender. The privilege granted to the lender is a claim against the property, so that if you don't pay the promissory note, the lender can then do an in rem suit against the property. They don't have to sue you and then get a claim against you and ask the claim for a judgment. They get a judgment against you and then ask the court to place a claim against your property to satisfy the judgment. That wasn't acceptable because from the period in which the note was originally secured to the point of the default, if the bank didn't have a claim on the property, you could just sell the property and liquidate their collateral. So the mortgage maintained the integrity of the collateral. If you're in a non-judicial state, you gave another privilege. The the lender didn't even have to go to court and do an in rem suit against the property because you gave a confessed judgment of the claim against the property. So they can move directly to liquidate the property. But they can only do that based on a default on the security instrument. And what we do is go back and look at the security instrument. First, we want to look at the public record. And from the year 2000 to date, the public record is one horrendous mess. The reason it's a horrendous mess is, let's go back to those tranches that I mentioned earlier. The lenders aggregate together these massive group of notes into a pass-through trust, and then they slice tranches off those trusts and sell them off to different entities. And they may have 3 or 4 of these REMICs working at one time, and one of them's making a profit, another one's not. So they'll take a tranche off one of those and move it over to the other one to even out their income streams so that they lessen their tax burden. Problem. It sounded like a great idea to take a long-term commitment, a 30-year mortgage, and sell it to a investment entity that needed a long-term investment, your retirement funds. That looked like a great idea. The problem was real estate-backed mortgages had reporting requirements that other kinds of securities did not have. Any change in the beneficial interest in the note or security instrument must be reported with the county recorder. Problem. You got a tranche here. You got the trust here with 10,000 notes bundled in it. You take a tranche off of that. You take a percentage of every one of those notes and you move it to another holder. Each one of those has to be reported to the county recorder's office by law or by contract. It's actually in the contract that any change will be noticed. Well, the cost of that would be prohibitive. They take a 2% off of one of these pools, and they got to do 10,000 notices at $30 a pop. That's just what you pay the clerk, not counting your own labor you have to pay to get it done. So they come up with this great idea. They create this company called Mortgage Electronic Registration Service. And Mortgage Electronic Registration Service would stand as a straw man agent for the borrower, for the lender, and all the lender's successors and assigns. So MERS stood in the front as the person to go to who held the beneficial interest of the note, and behind them, the actual beneficial interest was sold back and forth, and in this way, they didn't have to do all this reporting. MERS told the Supreme Court of Kansas, when Kansas addressed this issue, that the requirement that all changes in beneficial interest in real property be reported to the clerk is archaic, cumbersome, and costly. So we came up with this whiz-bang business model where we could eliminate that problem. And the Supreme Court agreed with MERS that the requirement to report changes in beneficial interest in real property is archaic, costly, and cumbersome. However, it is law, and we have no power to change it. So this was a huge scam, and if you look at the numbers, if you look at the charts, since 1900, prices have risen, real estate prices have varied dramatically up and down. But overall, if you average them out, they rose at a slope that was a little bit above the amount of green dollars the Federal Reserve put into circulation. It did that because the population steadily increased and the demand for housing has steadily grown over the years. So it was natural that real estate prices would increase and increase faster than inflation. And it's exactly what it did until the year 2000. Then the prices went straight up off the charts. Well, if you if you're in finance, you're going to be familiar with bubbles. You're going to know exactly what they look like. They look like an inverted bell curve. Take a bell and set it down on the slope. Prices start to rise at a slow rate, the flange of the bell. And then they start to increase, and then all of a sudden they head straight up. 2006, they went straight up. They rounded off the end of 2006, beginning of 2007. They leveled off at the top of the bell. And then in late 2007, early 2008, they dropped like a stone. Well, anybody who's been in finance is going to know that's exactly what's going to happen. So they gave you a loan on this property when the value was low and used these predatory loans to increase the apparent demand for property. The demand appeared to increase, but it actually didn't. There was a lot of flux in the market. People who were in a home that they could afford because they bought it under the prohibitions of the Glass-Steagall Act and the prohibition against derivative sales, protected the economy, protected the housing industry, so the prices were where they should be. And then when those protections were taken away and they unloosed the money changes on us, the prices started up, and they went to everybody and said, you got this house here and you can make a lot of money with it. Throughout history, that was one of the things that had been absolutely prohibitive. Never, ever speculate with your home. They got people to speculate with their homes. Sell the one they got and replace it with one more expensive that you couldn't really afford. However, prices are increasing so fast that within a year, you'll have a tremendous amount of equity in this, and your prices, your costs will go down. Well, they forced up the value of these properties and then watched the bell curve. And when it got to the top, they crashed the market. Turned over as many of the properties they could before they pulled all their money out of these properties. And then they watched the market crash. And now that the market's at the bottom, all these buyers are coming in and buying them back up again. These kinds of fluctuations in the market have been engineered since we've kept records. You hear the story about the Templars. The Templars went to Israel and they found a treasure under the Temple Mount. I don't think that's true. I don't think they found a treasure under the Temple Mount. They found a treasure over the Temple Mount. They didn't bring back secret relics from the Holy Land and a vast fortune. They didn't have a vast fortune in the Holy Land. What they brought back was the banking system. That was their treasure. That's what made them incredibly wealthy. They learned how to operate a banking system that you crash every 50 years. Every generation experiences a crash where the bankers gather up all of the property, they mortgage it out to the people, and the people go to work and struggle and strive to be able to pay off these mortgages. And then right at the next generation, they crash the market and take it all back. And then they mortgage it out to the next generation. This has been going on since the Templars came, since the Jews. Go back and look at the Jubilee. The Jubilee, every 49 years, all the property goes back to the original holders, and they start leasing it out again. And in Israel, you couldn't buy property; you could only lease it for 50 years. And after 50 years, it goes back to the original holders. The Templars brought that from the Holy Land, and they've been running that routine for the last 2,000 years, or actually 1,300. They were about 1200 they come up with it. So it's been about 700-800 years. But if you look back in history, about every 50 years, there's a major economic adjustment. These are engineered. We have people complaining about the Rothschilds and the Bilderbergs, but they seem to miss what they're really doing. They're not doing anything special or different. They've been doing the same routine for the last 700 years. We just need to pay more attention to it. And right now, the housing market is at the bottom of the bell curve. For the last 6 years, I've been telling people, do not invest in property. If you're in property, get out of property. Dump it because prices falling like a stone. Now, buy property. Property's at the bottom. This bell curve has bottomed out and it's starting back up. Now's the time to buy property. But these guys with big money, they already knew that. And they're buying all the property they can get a hold of, and we're doing everything we can to stop them. Foreclosure means they exercise a right based on your default of the security instrument. Your defense. Forget bifurcation. Forget separation of the note and the security instrument. Forget arguing about MERS. Who cares? Those are rabbit holes the banks are sending you running down. Go back to the contract and read it. I guarantee you that before the bank accused you of defaulting on the contract, they defaulted on it a number of times. The security instrument grants a privilege to the bank that can only be exercised if the bank is in good standing with the contract. If the bank breaches one of those covenants in the contract, they have defaulted. And once they've defaulted, they have voluntarily repudiated the contract and can no longer claim the privilege. If you argue that there's no money, that bifurcation separated the note and security instrument, that MERS can't be the beneficiary, in order for a judge to give you a ruling on those issues, they would have to give a ruling that would change the legal landscape as they know it, and judges really hate to do that. So don't do that. Go back to read the security instrument. Look what they've done. Did this lender, when he funded the note, did he really fund the note? Or did he give partial disclosure to you of facts that would give you reason to enter into a contract while withholding information that you did not have equal access to? And that had you been in possession of this information, you never would have entered into the contract. That's fraud by non-disclosure. Did the lender cause a change in the beneficial interest in the note and fail to report that beneficial interest as required by law? If you did, go to Covenant 16, where both parties agree to abide by all law. If you try to enforce the consumer protection statutes, they're all a fraud. The Real Estate Settlement Procedures Act, Truth in Lending Act, the legislature put those in and jumped up and down and waved their arms at the public and say, oh, look what a great deal we did. We put in all of these protections. Problem is you only got a year to exercise the remedy. Made them worthless. So, don't claim a violation of Hopatila Respa. Claim a violation of Covenant 16, breach of contract. Breach of contract does not have the statute of limitations. Breach of contract applies for the whole 30-year term. Once they breach the contract, the bell's been rung. They can't unring it. They repudiate the contract. It's much easier to ask a judge to look at this particular contract And this particular action and how it violated this particular covenant, that's easier for him to render a ruling on because it only affects the case that's in front of him at the moment. And you can make these claims in the form of a petition to quiet title. Petition to quiet title is kind of a stealth attack. You go to the court and you say, Your Honor, the defendant filed this document with the county recorder. But this document, when it was filed, did not meet the filing requirements of the state. And therefore, this court cannot see this as a valid document and ask the court to rule that the document is void. You're not asking the court to rule that the bank does not have a claim against you. Only that this document they filed is void and unenforceable. Or they filed the document. It was valid when it was filed, but subsequent to the filing of it, they defaulted on the covenants, rendering the document void. If you get the document rendered void, now you file Chapter 7 bankruptcy. In Chapter 7 bankruptcy, you claim the property as unsecured. Puts the bank in a position to provide a proof of claim to the trustee, but since they have no security instrument, they can't put a claim against the property. They can only bring an unsecured claim against you, and the banks will discharge that. And they are toast. This is one of a number of strategies that we have. I could go all night on this, so I don't know how long you want me to go, Andrew. So I'm going to call it off here unless you have questions.
No, I don't really have any questions. You're actually coming on a lot more audibly, breaking up for like a second every so often, but it's not getting all choppy like it was before. That's a little reassuring. We have 20 minutes left, so if anybody wants to call in, I'll let you get on these last 20 minutes or so, maybe 5 minutes per caller if we get all callers. But the guest call-in number, 646-478-4747. That's also for people who want to call in, not just the guests. So please call in again, 646-478-4747 if you have any questions for Randy Kelton in these last 20 minutes or so. But Randy, since we're on the subject of money, we had the Super Bowl recently, and the subject of illegal gambling often has come up. Now, a lot of gambling that's illegal, people might say, well, it shouldn't be illegal. It's your right to gamble, and if you're not causing any harm to anyone or anything, there can be no crime. I mean, what Michael Vick did to those dogs, I mean, that's a case where there's harm, so I think you would certainly be able to charge him with a crime for something like that. Michael Vick, the quarterback in the NFL, but there's lots of other gambling markets that are illegal that probably shouldn't be illegal because you're not harming anyone. So can you, to the best of your knowledge, elaborate on when illegal gambling market truly is illegal in reality?
Well, in that case, I agree. Prostitution, gambling, drug use, these are conscious volitional choices. And not just that they're conscious volitional choices. I am an engineer, and an engineer, we don't have a lot of ideas about how things should be. We tend to be pragmatists. This is how things are. Since human beings have been human beings, they gamble, they hire prostitutes, they take drugs. We can pass all the laws we want to, and nothing has ever fixed that problem. We're kind of like the guy who goes to the doctor and he says, Doc, I broke my arm in 3 places. And the doctor said, well, seems like you'd stay out of those places. Human beings seem to have a problem thinking they can convert moral beliefs into law. When you read the Bible, The Bible very clearly says, render unto Caesar. Morality is the Bible's business. Law is the state's business. And when you try to mix the two up, I'm someone who's not particularly religious. I very much see the value of religion. But I also see that religion is a choice. And we can't take our moral beliefs and superimpose them on human beings. Human beings, there are characteristics that we have, and all the laws we can come up with is not going to change those characteristics. So we need to find a way of dealing with these issues, and just making it a crime is not a good strategy. The drug war. It was the drug war that turned this country into a police state. Average conviction rate for all crimes across the board in Texas, and so far in every other state I've looked at, 99.6. It rounds up to 100. By far the worst police state in the history of mankind, and it came about because of the drug war. We passed these horrible laws in order to try to regulate the drug trade. And the ones passing these horrible laws were the ones participating in the drug trade. The Clintons, the Bushes, they were the ones benefiting from the drug trades. And they're passing laws to make it prohibited so they can make more money selling it. And the FBI will readily admit, they have reported this since the 80s, that their drug interdiction efforts have yielded nothing. That crime has decreased across the board every year since the early 80s. And the FBI readily admits it has nothing to do with law enforcement. It has to do with population. It has to do with the economy. It has to do with education. It had to do with human beings. So while I'm not saying we shouldn't have any laws, we need to quit trying to regulate morality. Drug use has been a problem always, but it is much less of a problem when we treat drug use as a condition, as a addiction rather than as a crime. Alcohol. Look what we tried to regulate alcohol. We tried that. That didn't work. Drugs, if we decriminalized drugs, the drug cartels would go away tomorrow. And we would do like the Netherlands and some of the northern European countries. They put in treatment programs, and their drug problem just almost goes away. It doesn't go away completely, because human beings get addicted to certain products, and they're always going to get addicted to it. But the big issues go away. So gambling, the idea of making gambling is illegal is just absolutely ludicrous. So that's my story on that one. I can't see any reason. They claim that it breeds corruption. Well, fight the corruption. Fight the crime, the gambling. Quit fighting something you can't fix. That's from an engineer's perspective. Did that make sense to you? Andrew, did I put you to sleep? You may have dropped off again. I know I sound kind of opinionated, but I'm not really. I'm really an advocate of law. I'm an advocate that the law be enforced by everybody. If we can get it evenly enforced, a lot of these problems we've been having will simply go away. Are you back, Andrew?
Hi, Randy. Sorry, I was on mute. I was talking, but I didn't realize I was on mute there. So I am back. Sorry to interrupt you there, but a lot of problems with Blog Talk Radio when guests realize that they're not on mute. Don't realize that, but I did, so I'm back. And we got about 12 minutes left. One thing in the language of legalese that I want to cover, I've heard from some law experts that if at any point you answer yes to if a public official asks you, do you understand, what they're really asking you is, do you stand under our authority? So if you do that, you've given up your rights, and they can charge you with pretty much any crime they want. And there's another example that I'd like to possibly discuss, like in the language of legalese. If they say you may, what they're really telling you is you must. Okay, so those are two examples of legalese I want to cover. When you say you understand, you are actually saying I stand under your authority, and when they say you may, they're really saying you must. Can you elaborate on what that means?
Okay, this thing about understand, that sounds like the kind of thing Aladask does. And I've heard that rendition, but every time I hear that, all that comes to me through that is a lot of political theory or legal theory. Never have I seen a word in law anywhere that says if you understand the law, you are necessarily bound to the law. Never found that anywhere. And one of the things that I tell people, if you're going to be dealing with the courts, never make a proactive statement of law out of your own mouth. You must make proactive statements of laws out of the mouth of the legislature or the courts. Otherwise, they're meaningless. You can go into court and give the judge the most eloquent argument and the most compelling reasons as to why he should rule in your favor. And he will sit there and listen to you intently, and he may even agree with you 100%. But if you do not deliver to the judge the facts in accordance with the rules of evidence and the law as it applies to those facts, the judge has no power to rule in your favor. So when people start telling me things of this nature, the first thing I want to see, show me some support. Show me something so that I can go to the court and say, no, I do not stand under. Stand under, that means subject matter jurisdiction. That goes to a challenged subject matter jurisdiction. Now, I can understand the law and not have the law apply to me. I will be going into court tomorrow morning at about 10 o'clock, and I'm going to hand the clerk a challenge to subject matter jurisdiction. Then I'm going to approach the court at arm's length and notice the court that I am coming at arm's length to the court and challenge the subject matter jurisdiction of the court. Now, I understand these laws very, very well. I understand them much better than this court does because I've been in front of it before. So while I understand it all, that does not mean I stand under. I stand at arm's length. So, what was the other one?
The other one was when the courts are saying you may, M-A-Y, you may, like you are able to do that. When they say you may, what they're actually saying is you must. You must follow our orders. That's what they are really saying when they say you may. I've heard that from a couple of people who've talked about legalese. Is there any truth to that?
Nonsense. Now, okay, well, with that said, sometimes may can be equated to must if where you are required to do a certain thing. For instance, if you observe a felony crime being committed, you may go to any policing agency, you may go to any magistrate and report that crime. In that instance, you must, because the law makes it a statutory requirement to notify the court of a felony, if you have knowledge of a felony. If you have knowledge of a misdemeanor, you may go to the police, you may go to some magistrate, the courts, and give notice of that crime. That means that you can do that if you want to, but it does not equate to must. This is a term that I have dealt with a lot, because in reading the judicial canons, it says the judge may do this, the judge may do that, the judge should do this, the judge should do that. And I'm saying, Ken, someone I work with, he explained it in a presentation to the Sunset Commission. In Texas, we have Sunset Commissions. Every, I think, 12 years, an agency comes up for sunset. They have to come before the legislature and show cause as to why their agency should not be eliminated. So he went before them and he raised the issue of the canons stating should instead of shall. That's like saying you should not rob a bank. Okay, you can rob a bank if you want to, but you really shouldn't. You shouldn't take hostages. You shouldn't shoot people. The canons of judicial ethics say the judge should not do this, the judge should not do that, but it places no mandated strictures on the judges. Makes the canons of judicial ethics absolutely worthless because they use should and may instead of shall and must. That's my position on that one. And this goes to a really important issue and something that we all need to fully understand. You don't speak English in court. I know English is the national language, but when you go in court, you're not speaking English. Yeah, it sounds a lot like English, but it's not English per se. It's a very specific English dialect called legalese. We had a guy in Chicago before a federal court objected to the proceedings and told the court that he did not speak legalese and requested an interpreter. And the judge appointed him a lawyer to act as an interpreter because he knew full well what the person was talking about. Person. If you cannot define the term, you don't know what it means. Especially when you go into a court proceeding, anytime you're going to reference a statute, look at the body of law the statute came from and see if there are a set of definitions in the beginning of the chapter that the statute's in. Read those definitions. Now, a lot of these guys in legal reform, they take those definitions and they treat them as if they are global. They're not. You can't take a definition out of the traffic code and use it in the IRS code. You can't take a definition in the IRS code and use it in the penal code. You must use all of the terms that are defined in the code, the way they're defined there. The next set of definitions should come from Black's Law. Never quote Black's Law. Quote the case law in the definitions in Black's Law that support the definition, not Black's Law itself. If you can't find it, if it's not defined there, then you can use the term as it's used in general parlance. If you go before the court and you're a pro se litigant, and if there's a term that you're not certain as to the definition of, like person, object and ask the court to direct counsel to define the term as he uses it. You see, most people, when they hear the term person, they think person means a living, breathing human being. And in the real world, that's what it means. But in legalese, it also means a legal fiction. A corporation is considered a person under law, as a corporation has certain rights under law. Like the corporation has a right not to be stolen from and not to be defrauded. So a person can mean a living, breathing human being or a legal fiction. It is incredibly important that you understand that. And kind of as an example, consider the word the, T-H-E. What does it mean? Every time I ask this, we use one of the most common words used in the English language, but almost nobody can define it. It means one previously mentioned. Define your terms. Know what terms you're using. I had a teacher once tell me, if you're reading a book and you come across a term you don't know the definition of, just look at the context and you should be able to figure out what it means. I tried that and then compared what I thought it meant to the dictionary definition, and I was never right. Make the dictionary your friend, and if you're using the internet, it's really easy to do that. You can look up terms quickly. It looks like we're about out of time. Andrew, you want to close us out?
Yeah, Randy, I guess so. We might as well close this out now. Yeah, I'm here. Sorry, it seems to take a couple seconds after I unmute myself to actually unmute myself. But anyway, we might as well close this out here. Got 2 minutes left, but it'll not worth it anyway. So, Randy, I'm going to tell you the same thing I tell all my guests. I loved having you on, but there's a lot of other people who deserve a chance on my show. So my policy is try to get as many different people on my show before letting any one specific guest double dips. So I'd love to have you on again. It probably won't happen in our lifetime because there's a lot of other fascinating individuals on planet Earth who deserve some glory on my show. So, Randy, glad I was able to pick you to come on my show. I learned a lot of stuff that I wasn't able to cover with your Rule of Law co-host Eddie Craig when he was on my show. I'm glad you finished that up. So I'll be listening to your show. I don't listen to the Friday night show, but I do listen to the Thursday night show whenever it happens. And it's been a while since the LogosRadioNetwork.com archives have been up, so hopefully they'll be able to speed that up. I want to listen to a couple of the shows there. But, Randy, thanks for coming on. It was a pleasure to have you, and I'll be calling into your show, I guess, if I have any other questions about the law.
Okay, you are welcome, and thank you all for listening, and good night.
Good night, Randy. Well, folks, Randy's off the air, so that was a great show. I learned a lot of down-to-earth things there in regards to the law. Hey, if you don't understand law, you won't understand a lot of other things. Once you understand how the law is screwed up, then it'll open up a whole new can of worms in your life where you can study things like, extraterrestrial cover-ups and whatnot. But anyway, Randy was a fascinating individual. I mean, even though I'm sure he would say, don't worry about your difficulties understanding the law, I can assure you that mine are still greater. Just like Einstein says, don't worry about your difficulties in mathematics, I can assure you that mine are still greater. And I'm going to tell you folks right now, don't worry about your difficulties studying the nature of reality, I can assure you that mine are still greater. And that's one of the reasons I created this show, to learn more about the nature of reality. But as far as the future goes, next week I am scheduled to have The Fix Is In author. The book is called The Fix Is In. The author is Brian Toohey. Brian Toohey will be the guest on my show next week, and really interesting story I want to talk about after I get into the news when I let Brian Toohey on about how I found out that Alex Jones is obviously lying when he says that he interrupts people a lot because he knows what you're going to say. I know Brian Toohey is going to get a kick out of that. I'm sure Alex would get a kick out of it if he heard it. I sure got a kick out of it. It was really disturbing at first, but it worked out nicely in the end. So that's my show. Brian Toohey will be talking about sports being manipulated and also some police state stuff, because I believe he did write a book about police state stuff as well, but mostly about how the world of sports is rigged in America and all over the globe. So Brian Toohey next week. Namaste, everybody. Have a wonderful life through infinite consciousness. Namaste.